Unfair dismissal laws have been part of Australia's workplace framework for decades, designed to protect employees and ensure fair process. But are the so-called access restrictions now largely irrelevant? To unpack that, we're joined by Jordi Poor from People and Culture Strategies. Jordi, welcome back. So, what are the changes that are ahead there, just as far as those unfair dismissal laws are concerned?
Yeah, so to put this in context, Andrew, when unfair dismissal laws were first introduced in the 1980s, it was intended that not all employees should have access to unfair dismissal. It was primarily intended for lower to middle income earners. It certainly was not intended that those who were senior executive at senior levels of management who would be on high levels of income would have access to being able to bring an unfair dismissal claim. The reason being that one of the remedies under unfair dismissal laws was that you could be reinstated, and the thinking was, well, someone who is a lower income earner is probably going to struggle if they're put out of work without there being a proper process or a fair reason. And for that reason, one of the critical exemptions for people from being able to bring an unfair dismissal claim was their income level. Now, over the years, that's been ratcheted up indexed in accordance with CPI, and it currently sits at $183,100. So you have to be earning less than that amount annually as your base salary in order to bring an unfair dismissal claim. There are a few other exclusions. For example, if you haven't completed a minimum period of employment, under recent changes, more relatively recent changes, if it's a redundancy, strictly speaking, you can't bring an unfair dismissal claim either. So this was the way in which it's always been set up, and there have been a few tweaks. But what that was intended to do was to really preclude people, and if I just focus on that income point, those high income earners from being able to bring an unfair dismissal claim. And what we've found has really changed is that those who are now earning well above that amount, and often to the tune of millions above that particular amount, are still able to challenge the fairness of their dismissal. They just don't do it under the auspices of bringing an unfair dismissal claim. And so what we have seen for a number of years now, and it's now becoming so commonplace, particularly in Sydney and Melbourne in particular, that basically almost every dismissal is going to be challenged.
So, I mean, does that make unfair dismissal laws as they stand then perhaps irrelevant in those cases?
Well, in practical terms, it does, because what we find, and if I give you a prototypical example, let's take a senior executive who may be on a package of 350, 400,000 or more than that. It's very easy for them to trigger a claim under what's known as the general protections regime, which was something that was introduced in 2009. So we've had it for coming up to 2 decades now. The idea behind the general protections regime was that regardless of income level, a person should be able to challenge their dismissal and indeed other things that might happen to them in the course of their employment, if that has happened because of a protected attribute, for example, their race, their gender, the fact that they took parental leave, or, for example, because they exercised a workplace right. For example, they made a complaint that they had been bullied at work, or they made a whistleblower complaint, or something along those lines. So the thinking behind that, I think, has always been easy to understand and quite sound. But what we have found happens quite regularly is that those senior executives will use a general protections, or what's sometimes referred to as an adverse action claim, to bring what is effectively a de facto unfair dismissal claim. In other words, they might say, under the auspices of saying, well, I raised an issue of bullying while I was in my employment, or I raised a concern about how the board was conducting itself, or how the CEO was conducting themselves, and I'm going to say that amounted to a workplace complaint, and for that reason I'm going to say that I have a valid general protections claim available to me. But really what that person is doing is challenging the fairness of their dismissal. And so this is something that whether we call it a loophole or whether we call it just an evolution of creative thinking by my colleagues in the profession, it's a very real problem, because this was never the intention behind unfair dismissal laws.
So do you feel as though perhaps they need to close those loopholes, if you like? I mean, where does this leave the law, given that perhaps any dismissal can be challenged?
That's right, and indeed, in the last few months, the president of the Fair Work Commission has made it very clear that the Fair Work Commission has become inundated with these general protections claims. So much so that we've seen in practice that the way in which these are being handled is far more efficient and quick, just because they are dealing with an extraordinary workload. And the reality of why they are so inundated with these claims is exactly the point that I'm making, that people are bringing de facto unfair dismissal claims disguised or dressed up as general protections claims. And while it's dealt with sort of slightly differently, they both start in the Fair Work Commission. They are both meant to start with a process of conciliation. It's just what happens after that, whether it's dealt with in the formal court system or whether it stays in the Fair Work Commission. That really doesn't matter, because it's still tying up a lot of public resources and Fair Work Commission resources. But far more relevantly, it's making a mockery of the remuneration limitation, which was always intended to be a fundamental part of unfair dismissal laws in this country.